We have answered the question whether an application for anticipatory bail under Section 438 of the Code of Criminal Procedure, 1973, is maintainable at the instance of an accused while he is already in judicial custody in connection with his involvement in a different case. Our final conclusion is as under. An accused is entitled to seek anticipatory bail in connection with an offense, so long as he is not arrested in relation to that offense. Once he is arrested, the only remedy available to him is to apply for regular bail, either under Section 437 or Section 439 of the CRPC, as the case may be. This is evident from Para 29 of Gurbakh Singh CBI. 2. There is no express or implied restriction in the CRPC in any other statute that prohibits the Court of Session or the High Court from entertaining and deciding an anticipatory bail application in relation to an offense, while the applicant is in custody in relation to a different offense. No restriction can be read into Section 438 of the CRPC to preclude an accused from applying for anticipatory bail in relation to an offense while he is in custody in a different offense, as that would be against the purport of the provision and the intent of the legislature. The only restriction on the power of the court to grant anticipatory bail under Section 438 of the CRPC is the one prescribed under subsection 4 of Section 438 of the CRPC and in other statutes like the Atrocity Act, etc. 3. While a person already in custody in connection with a particular offense apprehends arrest in a different offense, then the subsequent offense is a separate offense for all practical purposes. This would necessarily imply that all rights conferred by the statute on the accused as well as the investigating agency in relation to the subsequent offense are independently protected. 4. The investigating agency, if it deems necessary for the purpose of interrogation/investigation in an offense, can seek remand of the accused while he is in custody in connection with a previous offense, so long as no order granting anticipatory bail has been passed in relation to the subsequent offense. However, if an order granting anticipatory bail in relation to the subsequent offense is obtained by the accused, it shall no longer be open to the investigating agency to seek remand of the accused in relation to the subsequent offense. Similarly, if an order of police remand is passed before the accused is able to obtain anticipatory bail, it would thereafter not be open to the accused to seek anticipatory bail, and the only option available to him would be to seek regular bail. 5. We are at one with Mr. Dave that the right of an accused to protect his personal liberty within the contours of Article 21 of the Constitution of India with the aid of the provision of anticipatory bail as enshrined under Section 438 of the CRPC cannot be defeated or thwarted without a valid procedure established by law. He is right in his submission that such procedure should also pass the test of fairness, reasonableness, and manifest non-arbitrariness on the anvil of Article 14 of the Constitution of India. 6. Under Section 438 of the CRPC, the precondition for a person to apply for pre-arrest bail is a reason to believe that he may be arrested on an accusation of having committed a non-bailable offense. Therefore, the only precondition for exercising the said right is the apprehension of the accused that he is likely to be arrested. In view of the discussion in the preceding paragraphs, custody in one case does not have the effect of taking away the apprehension of arrest in a different case. 7. If the interpretation as sought to be put forward by Mr. Luthra is to be accepted, The same would not only defeat the right of a person to apply for pre-arrest bail under Section 438 of the CRPC, but may also lead to absurd situations in its practical application. We have also explained why Narinderjit Singh Sahni should not come in the way of applying. So we are dismissing the appeal with a clarification that now the bail will be heard on its own merits. Beautifully read. Thank you. You are appearing? We have allowed the petition. We appoint Shri Justice Mohit S. Shah, former Chief Justice of the High Court of Judicature at Bombay, to act as the sole arbitrator. The fees of the arbitrator, including other modalities, shall be fixed in consultation with the parties. It is made clear that all the rights and contentions of the parties are left open for adjudication by the learned arbitrator. Fine.
In 1502, I'm not in the matter, I have nothing to do with the merits. But when your lordships were hearing the constitution bench on this issue, Lord, my lords were pleased to require the original file of the government to be placed for my lord's consideration, which was placed. Lord, if that can be returned.
Can be fair.
Yes.
When the 7-judge matter was going.
Yes, at that time, my lords.
Yes, of course, that. Make sure that is returned to the Solicitor General.
Lords, if I may, if I can mention, my lords, there's a matter for which we've sent an email. We have also gone between 10 and 10:30, as the lordships have mentioned. It's listed tomorrow before the single judge division bench of the Madras High Court. Despite judgments of the Madras High Court which say quashing petitions must be heard by single judges, about 30 matters have been heard and disposed of, dismissing the quashings. We are a little concerned.
Yes, all other mentioning applications, the moment we rise, I'll pass orders so that we'll have orders by the
Except for these are matters before your lordships, after notice matters. Lords, concerning the university which your lordships have been hearing in part, lords. Sorry, my lords. My lords, it was last listed before your lordships bench, my lords, on 13th of February, my lords. Since then, it has not come up. It's showing on 13th of October. It may not be deleted because there's some.
All non-deletion requests also just give us in an email and make sure that I pass
It
on.
previously pending this matter for listing. So after notice matter, Lord, 1100 crore award in my favor, upsetting 37,
Email.
and not a rupee brought in security.
Thank
And we had previously emailed, but it keeps appearing and disappearing from the list, Lord. It be not fixed. So replied. Last it was listed in March, to be listed in April. So replied.
My lords, may I mention two writ petitions which are already,
Say it on the email. It's a fresh matter.
no, my lords, only for non-deletion, my lords. The date
Okay,
is
just
showed
say
as last 3 days it was deleted, my lords.
Send an email with, I say NTD,
Email
I've
us.
even got a code, NTD, not to be deleted, and I initial it.
Yes, my lords. Problem.
You know, only thing is the reason I insist on emails is because then it's tabulated. So then it's easier for them
Yesterday
to
we have sent an email.
process it.
We have sent an email.
I have a tabulation by the end of the day, so that I would just say NTD and initial it.
My lords, this is a writ petition filed on 9/7, my lords. Defects were cleared on 18/7. Since 50 days, it is not being listed, my lords.
1 second. I'll tell him. Just send an email, I'll circulate.
My lords, may I mention a matter which is listed today before my lords? My lords, actually,
Wait for the matter to be
Lordship.
called out. Wait for the matter to be called out, yes.
Like,
Malas, we have filed Malas, the status report, which you have circulated yesterday. And then Malas, we've also filed the report of the State Health Department. Malas, they've not gone back to work, the doctors. Malas, 23 people have died in the process.
Now, what about the CBI? Has the CBI
Lord,
prepared a
my
status
report is ready, my lord.
We saw your status reports, which were.
Malas, we filed a separate application, Malas, which
Lord,
I think has.
I don't think I have the copy. I'm not complaining. I'm just requesting him, my lord, to give it to me right now. Maybe they have served, it has not reached me, or they have not served, whatever. my lord.
It's not served. It's not served.
Not served, my lord, they have not served on me.
Yes. Put it in a sealed envelope and therefore we.
Sir, sorry.
Okay. These for the parents. Say one thing, my lord, what is filed by Mr. Sibal is not served upon me. That's what he said.
It is not filed. It's not filed. It's only given to the
Sir, if
court.
they want to say something, why hide something from the CBI?
Well, like,
You've
let's
already
see
done
what
many
the-
things.
I mean, I think let's not get lost in.
Yes, Malas,
Yes,
otherwise.
Let's see what let's see the, first and foremost, let us find out what the status of the investigation is.
Yes.
So can you?
Not even with them.
residence of the, Mr. Solicitor, what is the distance between the residence of the principal of the Arbitration Medical College and the medical college?
15 to 20 minutes it takes, maximum.
More than 6.
We have answered the question whether an application for anticipatory bail under section 438 of the Code of Criminal Procedure, 1973, is maintainable at the instance of an accused while he is already in judicial custody in connection with his involvement in a different case. Our final conclusion is as under. An accused is entitled to seek anticipatory bail in connection with an offense, so long as he is not arrested in relation to that offense. Once he is arrested, the only remedy available to him is to apply for regular bail, either under Section 437 or Section 439 of the CRPC, as the case may be. This is evident from Para 39 of Gurbakh Singh CBR. 2. There is no express or implied restriction in the CRPC in any other statute or in any other statute that prohibits the Court of Session or the High Court from entertaining and deciding an anticipatory bail application in relation to an offense, while the applicant is in custody in relation to a different offense. No restriction can be read into Section 438 of the CRPC to preclude an accused from applying for anticipatory bail in relation to an offense while he is in custody in a different offense, as that would be against the purport of the provision and the intent of the legislature. The only restriction on the power of the court to grant anticipatory bail under Section 438 of the CRPC is the one prescribed under subsection 4 of Section 438 of the CRPC and in other statutes like the Atrocity Act, etc. 3. While a person already in custody in connection with a particular offense apprehends arrest in a different offense, then the subsequent offense is a separate offense for all practical purposes. This would necessarily imply that all rights conferred by the statute on the accused as well as the investigating agency in relation to the subsequent offense are independently protected. 4. The investigating agency, if it deems necessary for the purpose of interrogation/investigation in an offense, can seek remand of the accused while he is in custody in connection with the previous offense, so long as no order granting anticipatory bail has been passed in relation to the subsequent offense. However, if an order granting anticipatory bail in relation to the subsequent to him would be to seek regular bail. 5. We are at one with Mr. Dave that the right of an accused to protect his personal liberty within the contours of Article 21 of the Constitution of India with the aid of the provision of anticipatory bail as enshrined under Section 438 of the CRPC cannot be defeated or thwarted without a valid procedure established by law. He is right in his submission that such procedure should also pass the test of fairness, reasonableness, and manifest non-arbitrariness on the anvil of Article 14 of the Constitution of India. 6. Under Section 438 of the CRPC, the precondition for a person to apply for pre-arrest bail is a reason to believe that he may be arrested on an accusation of having committed a non-bailable offense. Therefore, the only precondition for exercising the said right is the apprehension of the accused that he is likely to be arrested. In view of the discussion in the preceding paragraphs, custody in one case does not have the effect of taking away the apprehension of arrest in a different case. 7. If the interpretation as sought to be put forward by Mr. Luthra is to be accepted, the same would not only defeat the right of a person to apply for pre-arrest bail under Section 438 of the CRPC, but may also lead to absurd situations in its practical application. We have also explained why Narinderjit Singh Sani should not come in the way of applying. So we are dismissing the appeal with a clarification that now the bail will be heard on its own merits. Beautifully read. Thank you. You are appearing? We have allowed the petition. We appoint Shri Justice Mohit S. Shah, former Chief Justice of the High Court of Judicature at Bombay, to act as the sole arbitrator. The fees of the arbitrator, including other modalities, shall be fixed in consultation with the parties. It is made clear that all the rights and contentions of the parties are left open for adjudication by the learned arbitrator.
Finally,
Fine.
In 1502, I'm not in the matter, I have nothing to do with the merits. But when your lordships were hearing the constitution bench on this issue, Lord, my lords were pleased to require the original file of the government to be placed for my lord's consideration, which was placed. Lord, if that can be returned. Yes.
When the 7-judge matter was going.
Yes, at that time, my lords.
Yes, of course, that. Make sure that is returned to the Solicitor General.
Lords, if I may, if I can mention, my lords, there's a matter for which we've sent an email. We have also gone between 10 and 10:30, as the lordships have mentioned. It's listed tomorrow before the single judge division bench of the Madras High Court. Despite judgments of the Madras High Court which say quashing petitions must be heard by single judges, about 30 matters have been heard and disposed of, dismissing the quashings. We are a little concerned.
Yes. All other mentioning applications, the moment we rise, I'll pass orders so that we'll have orders by the
Except for, these are matters before your lordships, after notice matters. Lords, concerning the university which your lordships have been hearing in part, Lords. Sorry, my lords. My lords, it was last listed before your lordships bench, my lords, on 13th of...
First. Therefore, my lord, I am taking it in that spirit. Please have a look at, my lord, this left-hand side and the right-hand side, my lord. Kindly go through it, my lord, with some, my lord, degree of attention. Your lordships, I have gone through, my lord.
That certificate, yeah. Yeah.
उसमें कुछ होगा था
May I answer? Well, the death certificate was given at 1:47 p.m. And the UD entry was at 2:55 at the police station. 2:55.
That is 861?
That's right. There's the second question, your lordships. Subsequent proceedings, whether the inquest report or the CJM's order and all other documents.
What is the GD entry by virtue of which 861 of 2024 comes into existence?
565.
565.
Yes. DD entry 565.
And what time is GD entry 565 recorded?
At night, Mullah. Oh, 2:55 p.m. Mullah. 565 to 2:55 p.m. I can hand it over.
So GD 565
At 2:55 p.m.
is recorded at 2:55.
Yes.
GD was
Yes, it's there.
23:30.
This is
But
certified copy, Mullah.
565 is merely a medical
This
certificate.
is a certified copy, Mullah.
Page 64.
Extract
I
from
have
the
the copy of GD
Tala
entry.
Police
It said
Station daily register. It's not a
23:30.
medical entry.
Look at 11:30 night. I have the copy.
No, I have a copy too.
Certified.
We have certified copy, we've just given it to the court. The inquest, Mullah.
What is the time?
Yeah, give yours. Just make sure, let's not.
Judicial magistrate,
420 to 440.
the judicial magistrate arrives and conducts it.
And the judicial magistrate arrives and conducts it. He comes at 410. And then the inquest is conducted at 420 to 440.
Inquest is videographed.
And the it is videographed.
Yes, and the same has been saved on a card which we can.
Civil also, second question, when was the search and seizure actually carried out?
Just 8:30 to 10:45. 8:30 to 10:45. The photographs had been taken before, Mullah.
8:30 in the morning or in the evening?
Evening, Mullah.
The body was found in the morning at 9:30.
That's
so
right.
it cannot be
Photographs were
before that.
taken Once the body was removed, Malaj, for postmortem, then only Malaj.
And by whom? There is some relevance. Therefore, my lord, I would like my learned friend to ask. There is some relevance.
Malaj, we have photographs from 12:45 p.m. onwards of everything that happened. We have the original with us.
Now, during the course of the previous hearings, and therefore I think though the investigation is going on, we can share this because you've all said it openly.
Yes, Malaj.
That there is evidence that there is a CCTV footage to indicate what time the accused
Yes.
enters the seminar room and what time he's exiting the seminar
Correct,
room.
correct.
Right? This is
Yeah.
shared with us. Now, obviously, therefore, there would be CCTV footage after 4:30 in the morning, throughout the day.
Yes, there
Now,
will be.
has the CCTV footage in its entirety been handed over to the CBI?
Yes, yes, yes.
Yes, we have taken.
Yes.
We have taken.
You have taken the CCTV
taken,
yes.
footage.
But we had to reconstruct the scene because of the distance. my lord.
But then,
It covers only a part.
Mr. Solicitor, how do you explain this statement in your affidavit at small Roman 3 at page 14? Just see the last sentence.
My report, my lords?
Yes.
Yes. Page 14, my lords.
Just one para above 7.
Yes, my lord. The SOC was apparently visiting you.
Have you handed over, as the Calcutta police handed over to the CBI, the entire footage of the proceedings which took place between 8:30 p.m. and 10:45 p.m.? Because CBI seems
Yes,
to have
yes, yes. Yes.
What is shared with us,
is about 27
minutes.
27 minutes, they say. The
4 clippings totaling duration to 27 minutes. And the proceedings conducted from 17:06, that is 5/6, to 22:45 hours.
Mr. Sibal said that
Well,
they have actually
I'm just
conducted from
taking
8:30 p.m., that is 20:30.
I'm just taking instructions.
Yes, yes.
Yeah. That's, yeah, all right. Two separate things, Malaj. Seizure 8:30 to 10:45. Video of that. Seizure 8:30 to 10:45 given. Then, Malaj, in parts, the videos have been given. In parts, there was some CCTV in hard disk. In parts, completely given, Malaj. There was some technical glitch. It was stored in part, but given in full. Hard disk is full. And he's made a statement that I've given it.
It's, in this context, I need to, my lord, come in, my lord, here, because there is something, my lord, which, according to me, is very, very serious, my lord. My lord, I want a flap. My lord, we have the forensic examination report. I will not read it, my lords. But one thing, my lord, is admitted. When the girl was found at 9:30, I'm sorry, but her jeans were removed and even the undergarments were removed and were lying somewhere nearby. So she was in a semi-nude condition. It is also an admitted position now that there were injury marks on the body and other my lord, areas. Now, your lordships may kindly see report. Give me copies. And this, my lord, this is a forest, my lord, your lordships may mark. They have taken the samples, they have sent it to an FSL in West Bengal, and this is the result. And
CFSL,
CFSL West Bengal.
Central Lab, not
Yes, yes, correct,
FSL.
correct. I'm not on anything else. वो कहाँ गया दूसरा? हाँ, यहाँ पे लगा. Lord, I have only one copy right now. Please see this, my lord. This is serious. And the CBI had to AIMS and other, my lord, Central Forensic Science Laboratory. The person enters, the body parts are not covered. The lead girl is made nude. There are injury marks, and this is the result of FSL. Therefore, who took the samples becomes relevant. Kindly, my lord, have a look.
The injuries are all set out in the inquiry.
This, my lord.
So this is
Lord,
CCTV camera 16. CCTV.
Which is what is this document?
for my lord, Justice Padiwala and Justice Mishra also. Just give me a minute. I'm just flagging it, my lord. My lords may just see, my lord, the highlighted part in the flap portion. There are two specimens or two swabs and the result.
Mr. Mehta, we have seen now the further line of investigation which is open. We do not want to comment in it in the open court, obviously, so that the course of the investigation should not be affected.
Correct.
We will give you a week's time. Tell us by next Monday what further leads have emerged during the course of the further investigation. We'd like a status report to be submitted to us by next Monday. Mr. Sibal, it's advisedly we should not be referring to what has emerged during the course of the investigation.
Yes, absolutely.
Let the CBI proceed on the basis of what they are now exploring,
Sure.
the leads which they are pursuing.
Sure.
And we'll keep it now on next Monday. So that
It's a holiday, it's a Tuesday.
Only a minute, only a minute, Mr. Lord, there is one IA which we have filed, IA 200162. Lord, where, Lord, your lordships may please, Lord, require.
Well, before my learned
CISF
friend says that, I just want,
deployment, only a minute. Mr.
before my
Sibal, if you
learned
don't
friend
mind.
takes up, just hold on.
If you don't mind, sir, let me just show.
No, it's on the previous
What is-
matter.
We'll just pass a short order on this.
Lord, the lady.
Well, I just- I
Just 1 second. We'll come back to you in a moment. Let's clarify this part.
Yes.
A status report has been, a status report dated so and so has been filed by the Central Bureau of Investigation. Full stop. Having perused the report, it appears that the investigation is in progress. Full stop. We direct the CBI to file a fresh status report by the next date of hearing. Full stop. List on so and so for considering the fresh status report to be filed by the CBI. So we take it up on Monday for, Tuesday for considering the status report, which would be then filed by the CBI. Let's see what happens between now and because a lot of what has been collected during the course of the last 10 days is subject to further verification. And
We'll also
forensic
investigate,
analysis.
my lord, who collected the samples, because this,
Fair enough.
and we will send.
Neither stop you, nor are we guiding the CBI that we want a particular line of investigation to be
Correct.
conducted. CBI is doing it. You have flagged issues in the status report. You tell us next Monday what further emerges.
Take, my lord, this also on record, the report of the FSL.
We'll return this back to you. Why should we retain it right now?
Whichever way, my lord, comments.
We'll return that back to you.
Just one more thing,
Just,
my lord, out of, my lord, the lady.
First, we'll retain only the second status report on the record. The rest of the papers we'll return back to you.
My lord, there are 3 lady companies, my lord, of CISF. My lord, they are not providing the accommodation to them. They have to travel, my lord, from CISF camp, which is 1.5 hours away from the state. My lord, thereafter, my lord, there are several things which we have requested. It is order dated 22nd. We are, my lord, almost 15 plus days down the line.
Well, as we have provided, in fact, if your lordship looks at our note, we have provided all that they wanted us to provide, everything that they wanted. Just give it to my.
The three companies
Yes.
of women constables
Yes, and
who
we
are
have
guarding the
separate
Adipur
accommodation for the
college,
women.
where are they presently housed?
Well, that's, I just show to your lordships, Mullah. Kindly see, Mullah.
Look, can I have at least that?
Yeah, we just give it to you.
Yes. And I'll also share what is not provided so that you,
Just give it to you.
at least henceforth you, instruct
Kindly
them
see,
to
Mullah.
provide.
Kindly see the accommodation.
Yes.
KMCP Day School, 2.6 kilometers, 13.13 minutes away. One company proposed things, one company 54 women personnel. Indira Maitri Shishu Kalyan Hospital, 6 minutes away. One company 54 women
No,
personnel.
when?
These
Because
have
we
been
have been
provided.
hammering since
Then
2 weeks.
3 flats in RMO quarters within so-and-so, on-site, 20 for 25 personnel. Currently, 20 CIFS personnel are staying in 2 flats of RMO quarters within the hospital, and the rest of the CIFF personnel are commuting from 12 kilometers away. And the school and Indira Maitri Shishu Kalyan Hospital were undergoing construction, and therefore these are identified by the CISF themselves, Malal. So we put them there. And most of the state police officers deployed by so-and-so come from far off places like Police Training Academy, Howrah, which is 22 kilometers away, Bodyguard Lines, which is 12 kilometers, and Police Training School, which is 10 kilometers. So, Malaj, I mean,
This is my instruction
and
as on
our status
10:30 today.
reports, Malaj, sets out everything.
No, as on 10:30 today, my lord, this is my instruction.
No, but we are telling.
Kindly have a look at this, my lord.
This is, this.
We should not be fighting on this, my lord. The
I agree,
CISF,
and therefore, exactly.
we requested for
once I have
handheld metal
stated-
detectors. We requested for door-size metal detectors. other
Everything is
equipment.
provided.
They provided that after 2 weeks, but this is
No,
still
no,
not
we
provided.
provided there.
Let's have a look at this.
Just a second. What is now remaining to be provided? Mr. Solicitor, you have
what I
seen this. They say for housing one company of women personnel consisting of 54 persons, they have provided at KMCP Day School, which is 2.6 kilometers.
Kindly have a look at 10:30. At 10:30, this is
Malaj,
yet.
let the registrar of the High Court go and see, Malaj.
Yes.
Let 10:30, my lord, this is at 10:30.
Let him go and see.
I don't want, my lord, I'm not enjoying.
Can we can we look at this for a moment, please?
Yes, ma'am.
Accommodation for one company provided in 3 locations as below. RMO Quarter, Ajikor Hospital, 20 persons. KMCP School, 40 persons. Indira Maitri Sadan, 30 persons. Likely to be handed over by evening today. 2 companies are
Yet to be provided
yet to be
accommodation.
provided.
Some security gadgets are provided, some are not provided. Lord, I'm not gaining anything by pointing this out. This is what is needed. Lord, if some incident takes place, Lord, I stand responsible now for the security, the CISF.
Just one second. Mr. Sibal, you just check, Ms. Astha Sharma, you can check with the officers.
Yeah,
In your statement, where you have said one company, 54 women personnel,
yes.
that covers one and the same company,
Or,
which has been
one
provided
company
at
or 54 women
KMCP and
personnel?
Indira Maitri or Shishu Kalyan
no, Malaj, it's
Hospital.
one company / 54 women personnel.
Right, but the same one company.
Yeah.
But now, as of date, they have deployed 3 companies. So the other 2 are yet to be provided by you.
My Lord, when
One
this is
second.
provided?
One
This
here,
is
Malaj,
provided
kindly see
yesterday.
Indira Maitri, that's the other one too.
Yeah, that's the second one.
That's the second one. It's in Indira Maitri, Malaj, which is
So
1.7
we are
kilometers.
trying to tally what they have handed over with what you have handed over. What they have handed over suggests accommodation for one company provided in 3 locations, which includes 40 persons at KMCP and 30 at Indira Maitri Southern, and 20 persons at RMO Quarter. Now, that indicates that only one company is taken care of. There are other 2.
According to us, no.
Persons plus.
Just ask the registrar to go and
Why
check.
don't you,
One
can,
company, why register?
can we suggest this? Why do we have to ask the registrar to do all this?
Because they are
An
contesting.
officer of the state government and an officer of the, a senior officer of the CISF.
We have done that,
Not one
On
company
ground, we have
can-
done that. They are not wanting, in fact, Malaj, on the ground, the story is different. Malaj, what can we say, Malaj?
But one
Alright,
company,
ऐसा लिख लीजिए.
90 individuals,
Okay.
90 officers.
Yeah.
A total of 3 companies of CISF personnel has been deployed for the security at Ajikor Medical College and Hospital. Full stop. Mr. Kapil Sibal, the state of West Bengal has in its submission indicated that provision for housing the personnel has been made thus colon ये इनके इसमें पेज 1 को tabulated chart ले लीजिए. Prima facie, it appears from the above tabulation that the prima facie, don't say prima facie, it appears from the tabulation. In the statement which has been placed on the record by the union government, on the other hand, it has been indicated that accommodation for one company has been provided in 3 locations, namely at bracket 1, RMA Quarter, dash Arjikor Hospital, bracket 20 persons, 2, KMCP School, dash 40 persons, semicolon, and bracket 3, Indira Maitri Sadan, 3, bracket 30 persons. and that the premises are likely to be handed over by the by the evening today. Full stop. In order to obviate any logistical difficulties, comma, we direct that an officer of the nominated, a sufficiently senior officer of the Home Department nominated by the state of West Bengal, and a senior officer of the CISF at the spot shall jointly liaise so as to ensure that all the three companies of the CISF personnel which have been deployed at the spot are duly provided for accommodation in the vicinity at par with what has been stated in the tabulated position set out above. Full stop. Next. In the event that any further full stop arrangements have been made for providing 6 buses, 4 trucks, and 3 light motor vehicles. Full stop. The 2 officers shall ensure that all requisitions, that necessary requisitions which are made by the CISF are duly complied with by 5 p.m. today. Full stop. Necessary gadgets for security purposes shall likewise be arranged no later than by 9 p.m. Today.
No, but that's,
As a matter of fact, this is also provided, must have been provided tomorrow, yesterday or day after. I don't wish to trivialize the magnitude of the problem I am dealing with.
One further
by
thing now.
saying
Maharaj, I have
non-professional.
3 issues that I wish to place before you.
Before we hear you on those issues, Mr. Sibal, what steps have been taken by the state of West Bengal for, because we had said that pending the finalization of the recommendations of the National Task Force, we would like the state of West Bengal to immediately put into place necessary measures which would bring into being some sense of
Yes.
security and
We have got a report, Maharaj, from the health department.
and
Just
provision of
sanitation.
adequate measures for the doctors,
Yes, yes.
nurses, and the paramedical staff.
Yes, yes, Maharaj.
Status report.
Status report that we have filed, Maharaj.
The health secretary.
Make a prayer, let the competence of the autopsy surgeon be also involved within part of the investigation. And also they had offered money so that they can, my lord, speak in tune of the police. This should also be within the purview of the investigation. That's my humble appeal.
Look, we need not pass any separate order because what you are saying is already a part of the status report. That the CBI is looking into all these aspects.
I appreciate just one thing, that this postmortem could not have taken place after 6 o'clock in the evening. There are standing instructions. Everything, my lord, will just kindly take the postmortem report once and just give me 2 minutes. I will show your lordships how this entire investigation has been compromised. After 6 o'clock in the evening, a postmortem cannot be conducted anywhere in India and in the state of Bengal when it is a rape and murder. There has to be a noting of the civil surgeon on the postmortem report that the Deputy Commissioner of Police or the Commissioner of Police has certified it. Then it has to go to the superintendent. Superintendent certifies it and then sends it to the postmortem doctors. These 3 postmortem doctors, one of whom is a professor of forensics, my lord, knows this, but still, what is the reason? The reason was to get rid of the body. What Justice Patiwala was continuously asking, the GD entry number 576. I will ask them to show Form 27, and I'll answer Justice Patiwala's questions in 1 minute. Form 27, please. Form 27 is the first information report. In the first information report, there are various columns. Column 3, C2 gives the GD entry number.
Column C?
C2 gives the GD entry number by which the FIR was started. The FIR was started by GD entry number 577. The UD case was 576, as pointed out by Justice Patiwala. It was registered at 11:40 in the night, 45 in the night. But in the history,
That was better the last time also.
in the history, Maharaj, in my last 27 years in my career, I have never come across a case where seizure takes place prior to the lodging of the FIR.
The FIR has been registered at 23:30 hours.
Yes,
Yes.
now, Maharaj, there was a previous FIR.
Along with
The FIR has been suppressed.
If you see,
I will show it,
3 doctors sign off on it.
I will show on the,
6:10 to 7:10. Let him say.
Let him complete his submission.
Dead body arrives, 6:10.
Mr. Counsel, please complete your submission. Yes.
Maharaj will kindly take one Lords will kindly take section,
On the, just tell us on the facts, what are you saying?
my lord, will kindly take the postmortem report and compare it with the UD case which was started. In the postmortem report, the lordships will see whether the clothes of the victim were produced before the postmortem doctor. The entire, the jeans, the top, the undergarments, everything was produced or not. Because as per the, I'll show the notification, they have to be sealed by the postmortem doctor and handed over to the investigating officer. If your lordship sees in the top whether the clothes were sent to the investigating officer of the UD case by the postmortem doctor. But I will kindly ask them to just give a copy of it.
Of the postmortem?
Postmortem. And allow me to
We've handed over the postmortem.
We have seen the postmortem report. Just show us the postmortem report.
We've handed it over.
Either the state of Bengal or the CBI.
Well,
Because we saw it last time, but since
Yes.
he's making a point, let's appreciate what the point is.
The parents wanted. We had a list of demands, including the parents.
Postmortem report doesn't even say at what time it is conducted.
Give it to us.
I'm sorry, that too.
Yeah. It says that at the time, everything is there. I don't know why you're making these.
Please tell us what the time of death is.
It's
Just
a
1 second.
condition of
Take out copy.
the subject, Millers, your lordships will find on the left-hand side.
lordships will kindly see at the top. First will be the videograph. Conducted by whom? No designation. Who is he? From where did he come? Nothing. Was the
Conducted
CD
by
on a
Shekhar.
rewritable CD or was it a non-rewritable CD? It has to be mentioned on the first line of the postmortem report.
Millers, the judicial magistrate was present during
is
postmortem
immaterial.
call for his report.
All the three doctors are part of the,
5 female doctors were present.
all are part of the North Bengal lobby.
Family.
Don't discuss such things here. Please.
My lord will kindly see the second line. It has to be at 4 degrees centigrade.
Postmortem report refers to Tala PS UD case number 861
Yes.
dated 9 August 2024.
Yeah.
No, that's where the mystery lies, because between 2:30 in the afternoon, when they say the GD entry was lodged, that is 5:65, and 11:30 in the night, there are only 10 GD entries in Tala police station. Lordship should kindly appreciate that. Between 2:30 and in the afternoon and 11:30 in the night, there are only 10 GD entries. Or was this entire thing manufactured? And Maharaj, this started way back in 1953. It was the first case in Bengal where GD entries are manufactured.
You know that, what he said. Everything will be clear. The judicial magistrate witnessed all this. Call for that report.
Not on magistrate or these.
I say it makes no difference.
Lord, give me a minute.
My lord,
Please have a-
every police station has a natural death.
Makes no difference, he said.
Sorry.
Lord, kindly have a look at left-hand side bottom, the finding. In the case of wounds, not note whether there is any indication of wounds being homicidal, etc. Then the report is death was due to effects of manual strangulation associated with smothering, as noted above. Now, please see manner of death, homicidal. There is a medical evidence of forceful penetration, insertion in her genitals,
Yes.
possibly of sexual assault. And see, my lord, the FSL report. My lord, I have marked, my lord, 2
CFS.
my lord, seized items.
Give us that.
Given that. I'll just,